just in the interest of time, I know your time is all valuable. We'll go ahead and get started on this presentation. I would just ask that you keep your line muted if you could, but please don't hesitate to jump back on and ask me a question at any time if you have one. I'll try to monitor the chat as best I can. Somewhere over here. There it is. And like I said, just please ask any questions that you might have during this presentation. So today's class, which will be for credit for those of you who need that CAI credit. Terry Rodriguez in my office can help you with that if you need that credit. You can reach out to her. But today we're going to be going over the legislative updates for this year, which we finally have some to talk about, thankfully. It's been a while. And we're also going to go over some case law updates, that some recent cases over the last couple of years that impact homeowners associations, condominiums in the state of Arizona. So if I could just ask everyone to mute their line again. We're getting a little bit of disruption here. Thank you. All right, so if you see on your chat, there is, hopefully you can all see that. There's a document we posted, which is a summary of the bills that we're going to be talking about today. If you're unable to access that, please just send me an email or send Terry an email and we'll get you a copy of that. And it just is a quick, very brief summary of each of the bills that have been signed, along with some of the bills that may still get signed. We're still kind of waiting on that, but we're going to go over those in more detail. But just look at the chat. There should be a link to that document, and you can reach out to Terry if you're unable to access that document. So, all right, let's get started here. And this is just a screenshot of that first page of that chart that is in the chat. So, as of June 3rd, these are just some of the summary of where we're at in the process with the legislative process. It's been a long session, as many of you, well, for those of you who follow it more closely than others, you know that the last couple of weeks, or maybe it's been more than a month now, they have been tied up in trying to pass a budget for the state. I was informed this morning, I'm a member of the Legislative Action Committee for CAI. I was informed this morning that they're very close to passing that budget. They finally made some tweaks. There's a dispute or a debate now over this flat tax. I'm not a tax guy. I don't really understand it very well, but I know that's what the hangup has been. And they've made some changes that have appeased the various groups that have been opposed to what was going on. And it sounds like within the next couple of days, they're going to get this thing done and then end the session. And so it looks like by the end of this week, this session will end. But as of June 3rd, you can see on the screen there of how many bills were posted. It was a very active session. I think there were a lot with COVID last year that kind of ruined everything. I think some of the legislators were very eager to get their bills out there for discussion. Of all the bills that were posted, you can see that 408 of those bills were passed. And 381 of them were signed with 27 vetoes. There are still some bills lingering out there, some of which affect our industry, which we'll talk about, that may still be signed, but that's where we stand currently. So as I said before, the session is likely to end this week, which is important because the bills that have been signed will go into effect 90 days from the day that the session ends. So you can kind of mark your calendars accordingly. If we're end of June, so July, August, it'll be the end of September when these bills that we talk about will go into effect. So just keep that date in mind as well. And I see some of you have commented about you're not seeing the link. So Terry and I will make sure we get you the chart that we're looking at. All right, so this is a kind of an overview, and then we're going to go into more specifics. These 7 bills that I have here, this is the list that I've come up with of bills that have some impact on associations. Some of it is a very little minor impact. Some of it is a little bit greater. But these are the 7 that have been signed by the governor. And then the 3 bills at the bottom are bills that are still out there, still alive. And there is a chance that these could be signed as well. So let's go into each one of these in more specificity here. The first bill is House Bill 2617. This is a bill that has an impact on various judgments, liens, the homestead exemption. Now, these bills could be grouped into different categories. We have a couple bills here. These first 2, the way that it will impact associations is in the realm of collections, assessment collections, the efforts that your management company or your attorney make in trying to recover those outstanding unpaid assessments. And for those of you who may not have heard of the homestead exemption before, or maybe don't quite understand it, the homestead exemption is a protection that has been created by the law, the protection that's afforded to owners in their primary residence. And before this bill was signed, homeowners were protected up to $125,000 of the equity in their home. So if a creditor was trying to collect on a particular judgment, and there are exceptions to this law, but on a particular judgment, if they tried to execute on that judgment by selling your house, which they may have the right to do, any money they recover from that sale, the first $125,000 that's protected would have to come back to the owner as part of that transaction. Now, if you have a first deed of trust, if you have other liens on the property, that all plays into it. But there are situations where you have this protection that you're afforded. What they did with this change in the law is they doubled that exception. The homestead exemption, I should say, is now $250,000, or will be in 3 months. And so that protection now has been doubled for owners in their primary residence. Now there are
And I just lost your sound.
Can everyone still hear me?
I can.
Okay.
I can hear you.
And
All right.
I can see the PowerPoint with all your stuff that you're talking about. I just didn't get any link in the chat. So
Okay.
I'm seeing whatever you're talking about on my screen.
Is this Tony?
Yes.
Okay.
Hi.
All right. We'll
I can see you and you have sound as well.
okay, perfect. All right. Thank you, Donna. Tony, we'll get you that. I have your email address here in the chat. We'll get you that chart as soon as we can.
Thank you.
So there are this particular bill does amend. I think there are 4 different statutes that have amendments from this bill, and some of them are a little bit complicated to understand. I don't want to get too deep into the weeds on this because this is something that if there's a question, I would advise you to reach out to your attorney for your association if there's a question that comes up. And your attorneys will know about this. They'll know how this exemption works and how it might apply in their efforts to try to collect. But one thing I will say that you should keep in mind is that the association's lien, and as you know, there's a statute that creates the lien on anyone's property for money they owe. That lien is exempt from this exemption. So the homestead exemption does not apply to HOA assessment liens that are created by the statute. So if we go to foreclose on an assessment lien under the statute, we don't have to worry about the homestead exemption. So it doesn't really apply. But there are situations where it may come up. So that's why we include it, just to be aware of that, because there are other judgments the association can get that become judgment liens, and then that can be impacted by this exemption. So I'm going to leave it at that on that bill. And as I said, if you have other questions, I'd recommend you reach out to your counsel and maybe they can answer that question for you. Now, the second bill that is along the lines of collections that I think many in the industry should be pretty excited about was an effort that was pushed through to revise the garnishment statutes. There are a set of statutes that allow associations as a creditor to garnish someone's wages or garnish someone's bank account in the event they have a judgment and they're trying to collect on that judgment. That's what we do in our firm, and I think every firm that does collections does that as well. It gets to a point where you have a judgment that says someone owes a certain amount of money, and that's the way we try to collect it. In the past, and when I say that, I mean maybe 8 to 10 years ago, in this industry, it was very common for an association to get a judgment that awarded a certain amount, but also awarded attorney's fees and costs that were incurred in collecting on the judgment. And most of our judgments still say that. But we would use that then to attach any attorney's fees incurred in doing a garnishment. We used to try to collect those just by putting them on the account and telling the judge they're owed, and we would get an order from the court garnishing the money, and it would include those fees. Well, in 2015, a case came out of Tucson that changed that and made it clear that attorney's fees for garnishments are not allowed to be awarded by a court, because there was nothing in the statutes at that time that awarded associations attorney's fees for their efforts in garnishing. So for the last 5 years, associations have been having to pay the money to collect to do a garnishment and to collect those amounts, or those firms that do some sort of different sort of collection arrangement have had to do that work for free to try to collect that amount. So the statutes now have been changed, and you'll see on that chart there are five sections of these statutes that have been amended. But the takeaway is that the statutes now will include language that allows a court to award the attorney's fees associated with the garnishment. So now we're able to recover those fees and put that on as the total that an owner owes, which I think is a very good thing for the industry, especially for associations, and they're able to recover those amounts now that they would have otherwise been paying to try to collect other money. So, and those amounts would be recovered through the garnishment process. So that's the main point of this bill, House Bill 2170, and again, it'll go into effect in 90 days, and the garnishment process will start to change at that point. The next two bills that I want to cover arise out of the pandemic, the COVID pandemic. This first bill, House Bill 2770, is a mask mandate bill. And that bill says that a business will no longer be required to enforce on its premises any mask mandate that has been established by the state or by any city, town, county, or other jurisdiction in the state. So if this were to happen again, or if the numbers go back up and there's a mask mandate put in place, or not a mask mandate, mask mandate put in place by the state, businesses won't have to enforce that on their premises. So it does impact associations in the sense that they would fall under the definition of a business, but as you'll see on this next slide, I'm not sure that how much it will be applied because of this next bill, and let me explain. So that was House Bill 2770. Senate Bill 1377 is the civil liability bill, and this bill again arose out of a concern. If we go back to a year from now, in June, July of last year, probably even before that, in May, our office was inundated with requests from managers and board members as to what do we do? How do we deal with this pandemic? How do we deal with all the CDC guidelines, the state guidelines, when it comes to our pools, our clubhouses, any of our common facilities? Do we keep them open? And if we keep them open, what do we have to do? Because if we're not careful, we're going to get sued. An owner's going to get sick, and he's going to sue the association because he contracted COVID. And so that, I'm sure many of you probably received that advice of what you should or shouldn't do, whether we should keep the pool open. So that then obviously would apply to any business, any place where people are coming and going. And so this bill was passed and signed to try to limit that exposure to businesses. And the definition of a business in this bill does include associations as nonprofits. It also includes management companies. And so the main entities, I guess, in our industry are protected by this bill. And what it does, when someone, if someone were to sue, let's just say the association, because they contracted COVID, they think it's their fault, the association's fault because they went to the pool and they got sick. Before this bill was passed, the standard for that owner, it would be a tort claim, a negligence claim, or maybe breach of contract. But the owner would have to, by a preponderance of the evidence, would have to show that the association had this duty and breached its duty by not properly cleaning or whatever they didn't do properly, and that resulted in this person contracting the disease, and then whatever damages they suffered. This new bill now actually makes it tougher for owners to do that. They now have to show with clear and convincing evidence, which is a higher standard, it's a higher threshold that they have to establish in court or in front of a jury, that their evidence is clear and convincing that the association either acted with willful misconduct or was grossly negligent. And again, those are legal terms, but it is a higher standard. It's almost like a reckless kind of standard that they'll have to show that the association did that in order to prevail on a claim like this. And then it goes further to say that an association or management company will be presumed to have acted in good faith and not this reckless standard if they can show that they've adopted and implemented reasonable policies that are related to this pandemic or whatever the public health crisis is. So our advice and recommendations would be that if this were to come up again, just like you did last year, where you probably had policies and procedures in place, either you closed the pool or you had cleaning requirements or mask requirements, social distancing, something that was in line with the CDC or the Arizona Health Organization. If you have those policies and procedures in place, then there's going to be this presumption of good faith that's going to be placed on you, which will protect you from, they won't be able to meet that burden of showing willful conduct or gross negligence because you have this good faith presumption. So that's why I was saying before, if not enforcing mask mandates, it may be kind of an interesting analysis if that's part of the protocol that someone recommends. You may want to follow that protocol just to give you that protection from any potential liability. So that is the gist of the civil liability bill. We're kind of on the downswing now with COVID. Hopefully that if we continue on this trend and it won't be something that we really have to worry about, but just know that it's there. And so if you have those policies and procedures in place, or you've had them in place, then that's good. And you should have that protection. All right, the next two bills that were signed both have to do with political signs. It was kind of surprising how many bills there were involving political signs this year. There were at least three that were tossed around. I think there was actually a fourth one that was there for a little bit. I can't remember which one it was, but two of them made it through and were signed by the governor. There's one that's still floating around that we'll talk about in a little bit. But I want to talk about both of these and the impact of both, because the second one particularly will impact associations directly. But the first one, Senate Bill 1432, is an amendment to a statute. And in all honesty, I did not know about this statute before this amendment came up, that there's a statute that makes it a Class 2 misdemeanor if anyone defaces a political sign or removes it during a certain window of time. You go around removing signs, or if the city comes in and removes a sign from a public right-of-way during a particular window of time, it's a Class 2 misdemeanor for the individual. I'm not sure how the city would be punished, but they're prohibited from doing that, is essentially what it is. And this window of opportunity, in fact, let me pull up Make sure I get this right here. So this particular bill, this 1432, made a change to where the window is 45 days before a primary election, and then 15 days. So starting 45 days before the preliminary primary election, and then 15 days after the general election. That's the new window of time where this punishment exists. This prohibition on messing with signs exists. It used to be 7 days after. They've changed to 15. And what they did in these two bills and the other bill that might be signed is they were trying to be consistent, because there were these different bills, different statutes that talked about political signs, and there were different timeframes. And so I think it was a little confusing. So they tried to make it consistent. And you'll see that in the next statute. But so now it's a 45-day window before a primary and then 15 days after. Now, this does not apply to signs that are put on private property. So if someone puts a sign on the common area, then you can take that down because it's not their property. But if you take out someone's sign on their own property within that window, then this statute could jump up and become a problem for whoever does that. Now, let me jump to, so 1722 was also passed and signed. It made changes to that same statute. The statute, for those of you who don't have the chart, is ARS 16-1019 is the bill that is the statute that was amended. And that one took that time period from 45 days to 71 days. Just look at this real quick here. Just had to print these off to make sure I get this. So let me restate what I said there. The 45 days still applies for individuals, but this bill changed it to 71 days for the city. So again, this part probably, the city part you don't really need to worry about, obviously, but if it comes up, there's this 71 to 15 days after is the window for the city. But you'll notice that 71 days, you'll know where you'll hopefully notice where that comes from is in the political sign statutes for condominiums and planned communities. They have that 71-day window. And so again, I think it was an effort to make statutes more consistent with each other when it comes to these political signs. But the one thing that we do need to be aware of for the statutes that directly impact associations, and this would be 33-1808 for planned communities and 33-1261 for condominiums, is they did come in and make a change to the political signs section in those two statutes. And the takeaway that what you have to know now is that in the past, as all of you probably know, that the window of opportunity for people to put signs up was 71 days prior to an election and 3 days after. And that has now been changed, and there were a couple changes to it. One, the 3 days after has now been changed to 15. And so owners are allowed to place signs 71 days before the general election or before the election 15 days after. But the other change they made, which is a question that would come up every once in a while in our office, was when does the elections, what election are we talking about? Are we talking about the general or the primary? Because that wasn't really clear in the past. And so they've clarified that now. So the new law will be 71 days before the primary election and 15 days after the general election ends. There's also, in addition to that any candidate who's in the primaries who does not advance to the general election, their signs can stay up for 15 days after the primary election ends. So it's 71 days prior to the primary, the signs can go up, and then they either have to come down 15 days after the primary for those who lose, or 15 days after the general. So that is a change that we're going to have to to implement. Obviously, don't have to worry about that right now, but when that time comes, you will have to be aware of that and know that no matter what your documents say, you cannot force someone to remove a political sign. Now, all the other language in 33-1808 and 33-1261 stays the same. So the sign, the number of signs, the size, none of that changed. It was just the time period in which they can place those signs. That's all that changed in that particular bill. All right. The last bill I want to talk about that was signed is House Bill 2367. Now, I do want to mention, do a kind of a little bit of a warning here that in all likelihood, this bill is not going to apply to most of your communities. I do have a question here. Let me just jump back to that 1722. There was a question here just to clarify this, the 1722 wouldn't apply to association common area, and that's correct. Associations can still govern what goes on in their common area. So if there's no political signs allowed in the common area, you can still enforce that. Nothing's changed on that. You still get to regulate what happens in your common area. So the only change, like I said, is just the time period. So whatever you were doing before with political signs, continue to do it. Just know that you have to adjust when you do it. So that's the big change. Good question, though. So back to 2367. This bill allows for a special event liquor license to be issued for certain events that have a charitable or nonprofit purpose. But it only applies to associations that have a 501c4 designation from the Internal Revenue Code. And I'd be willing to bet that most of your communities do not have that designation. Very few that I've ever seen in Arizona have that designation, have gone through the process to get that. I do know of one or two here in Maricopa County. So if your community is a 501c4 community, and don't just assume you are, there's a process you have to go through to get that designation. But if you are, then this bill will apply to you, and it will allow for a special event liquor license to be issued. There's more to this bill. I didn't go into a lot of detail because it probably isn't going to apply to most. So if you are a 501c4 association, reach out to your attorney and they can tell you more about this bill in the event that that issue comes up where there might be a need for liquor license. But again, it's on the list because it may impact some communities, but chances are it's probably not going to affect your community. So any questions on the sign bills, that maybe something I said or didn't cover that you're wondering about? All right, let me go to then. This was I just caught, so you're telling me there's a chance bills. Dumb and Dumber quote there. I say that because these bills have gone through either most or part of the process. And when I say the process, I'm still not well versed enough on how the sausage is made with these bills, but there is a process where these bills are introduced. They go to various committees, various votes are taken, different reads are conducted, and then there's a final vote, and then it's presented to the governor for signature. And these first two bills, 2030 and 2052, at the start of the session, we as a legislative committee, we've had our eye on these two bills from the beginning because they've been problematic from the start, and we've been trying as best we can to put an end to these bills, and they have gone through the process with flying colors. The 2052 bill, I don't think has received one no vote the whole time, but they're stalled out right now in the process, and from what I'm hearing, there's a good chance neither of these bills will actually be signed. They may close down the session and these bills just die. But I'm not going to say that for sure because who knows what will happen between now and the end of the week. These still could come up, and so I do want to talk about them in case they are signed, because these will have a direct impact on your communities and you'll have to implement some changes probably in your policies. So House Bill 2030 is a first responder flag bill. As you know, the statutes currently 33-1808 and 33-1261 for condominiums have a list of 5 flags that are protected from enforcement. The American flag, the Gadsden flag, the state flag, and I'm forgetting the others. But this bill will add a 6th flag to that list. And it will prohibit associations from taking any enforcement action if that flag is flown. And they call it a first responder flag, but this is a broad term. If this bill is signed, there will be 3 different categories of first responder flags that owners are going to be allowed to fly. One is, the first category is law enforcement. And in each one of these categories, if you read this bill, you'll see they've given a name to the category, and then each category has a color scheme that can be used, along with various words or symbols that can be placed on the flag. And it can be a variety of, it can be 2 of these different categories can be combined into one flag. So I think our hands are going to be full with trying to interpret whether or not this flag meets these requirements or falls within one of these categories or 2 of these categories. But quickly, the law enforcement bill, the flag would be a combination of a blue, black, or white color with words like law enforcement, police, officer, first responder, and it could have the police shield as a symbol. The second category is the fire department, which would have red, gold, black, and white colors with the words like fire, FD, firefighters, and it could have the Maltese cross symbol that you might see on there. And then the last category. Okay, so I think I left off on paramedics or emergency medical technicians, and that is a combination of blue, black, and white colors with words like first responder, emergency medical, or a generic star of life symbol. So again, as you can see, it's a very broad definition of what a first responder flag was, and this is something that we were trying to raise as a concern with this bill, is that it's so broad. It just is going to invite a lot of interpretation on the parts of managers, on the parts of board members to figure out if it is a violation or not. And I will tell you too, kind of in the background, this was a very contentious bill. During the process, there was a lot of, I guess, heated discussions between certain members of the Senate and the House as to what this bill meant. There's a camp that says, why are we restricting flags at all? People should be able to fly whatever flag they want. Some saw this as a racially motivated thing, the Blue Lives Matter type thing. Others took great offense at that. I mean, it was very animated in the process. But at the end of the day, it's passed through the committees, but it's just sitting there. So if this is to be signed, then the associations will just need to be aware of that and adjust their enforcement methods, I guess, to know what is a violation and what isn't. And it may have to result in questions being asked from attorneys or managers as to whether or not something is a violation. So the other bill I want to talk about is House Bill, and I just moved that slide here, is House Bill 2052. And that is another political sign bill. I mentioned there were multiple bills on this. But it's political signs and political activities is kind of the summary of it. What this bill does is it doesn't mess with the time frames. Those have already been changed with those other bills we talked about. What this does, though, is it goes in and it changes the definition of a political sign. I just want to find something real quick here. Put it off or not. The bill, as written, as you know, the current statutes define a political sign And it has to do, it's, I think, always been interpreted to deal with general elections, stuff that just happens every other year in November, and the signs attributed to that. There was a push by some out there that they felt that this needed to be expanded for purposes of protecting owners or whatever the idea might have been. But they've now expanded the definition of a political sign. And so not only will it cover everything that it used to cover, but political signs will now include any sign involving association activity, association elections, board removal meetings, or any sort of board or association action or ballot measure. Let's say they're doing you're trying to amend your CC&Rs or levy a special assessment. If people feel so inclined as to put up a sign in their yard, then that would be considered a political sign, and it would fall under that time frame of the 71 days prior and 15 days after. So if you kind of think about this and extrapolate this, it's not just going to be around the November time that we're talking about. You could have a special meeting or an amendment meeting in May, or maybe you have a board removal meeting in May. Well, now you have 71 days prior to that, so now you're going back into March. You may go into June. Worst case scenario is you could have signs up a lot of the year. Because it's not just for general election stuff anymore. If this is signed, again, this is not this is not a law yet, and there's a good chance it won't even be signed. But it's important to know. Now the other change, and then I'll get to the question here. Another change from this law has to do with political activity, and this same group that's been concerned about protecting owners felt that there needed to be something codified that made it clear that owners are allowed to use their common areas and common elements to mingle, to gather, and to discuss association business, and to peacefully assemble. And we were a little confused by this because I mean, in my understanding is that's what it can already be used for. I'm not aware of associations out there that are telling their owners they can't gather together on the common area. But it was a concern that was raised, so they're trying to pass a law for it to where associations would not be able to prohibit this activity from taking place in the future. You'll be allowed to impose reasonable restrictions through rules, but you won't be able to prohibit it. They took it a step further, though, during this process. They inserted language that says not only will owners be allowed to peacefully assemble, but owners are now going to be permitted to invite a political candidate or any other non-owner to speak to an assembly of owners on the common area. And associations will not be allowed to say no to this. And this is what we had real concern with as to the impact of this potential bill. I mean, there's history in Arizona with events, dangerous events at meetings. Who are we inviting on? Who are people inviting on? And as you can imagine, politicians were real excited about this because now this just opens up all these common areas to their political efforts. That's why there was not a single no vote in this process, because it was kind of a pat yourself on the back kind of bill. But again, it isn't law. And so hopefully it doesn't pass and we don't have to worry about this. But if it is signed this week, likely, if it'll happen this week, if it happens, then associations will have to adjust on how they regulate common area and the activity that takes place on that common area. Now, the last bill I want to mention on here, that this one out of the three is likely to be passed. There's a little trick that legislators can use that I just was now learning about. They call it a session law. They go through during the process, and at some point during the process, they can insert these amendments into a bill that has nothing to do with what they're trying to pass. Some of you may have seen about a month ago, there was a news story on ABC 15. I saw it on their nightly coverage. It was about an association in downtown Phoenix area that was a condominium, and an investor had come in and purchased most of the units and was going to terminate the condominium and convert it to apartments or something else. And the news found an 80-year-old woman who was nervous because she was going to be losing her condo, and they spun it, as you would imagine they did, to say how outrageous it is that a condominium can be terminated like this, and someone's going to lose their house, and this and that. So this made its way to a legislator who has taken action now. And House Bill 2891 is actually not a condominium termination bill. It's the budget bill that we've talked about. But within that budget bill, they've inserted this language as an amendment to 33-1228, which is the condominium termination statute. And the main push here is as you may know now, for those of you who live in a condominium or manage one, you can terminate a condominium with the approval of 80% of the owners, and there's a very detailed process that you have to go through. This change will make that a 100% requirement. And so anyone who wants to terminate a condo is going to have 100% approval from the owners. The interesting part about this change, though, is that it will go into effect, but as a session bill, it will only be in effect until June 30th of next year, and then it expires. And so this issue will be revisited next year for sure. Knowing that this will expire at the end of June of next year, I would imagine there are going to be efforts to make it more permanent in the future. We are opposed, and when I say we, I know CAI has not in favor of this, but it's a problem. I mean, 100% is, as you can imagine, it's never going to happen. And while it may not be a great thing to see a condominium terminated, there are instances, I think, in my opinion, where it's a good thing, where you have old, outdated condominium, can't pay its bills, has no money. Maybe this is a good thing for everyone involved to come in and terminate this. So that's something that we'll probably see again next year, and to make it more permanent, or have efforts to make it more permanent. Now, a question came up, and this is a good question. I've had this question a couple times about the flags, or I was about the political sign bill. But the question is, if a bill like this passes, do we need to be worried about other flag bills being brought up? Well, it was the flag bill. Yeah, I'm sorry. The other flags to be brought up, like a Black Lives Matter flag or LGBTQ, or other types of flags with those types of messages or causes. As it stands right now, those are not protected under this particular bill, under the law. If a person is in violation of a provision in the CC&Rs because of the flags, and it involves a Black Lives Matter flag, you could enforce. I had to do that about 6 months ago. Now, just because you can enforce it, maybe doesn't mean you should, but those aren't protected. I do have a feeling, though, that this will be revisited again, and I can imagine those might be added to the list for next year. So we'll see. We'll wait and see. But as it stands right now, you don't need to be worried about those flags. You can enforce. You may not get very good press in doing so, but if it's a violation, it's a violation. Now, whoops. I don't know what's showing up on my screen. You see the screen, is the screen up with, I need to fix this, with the headstones?
Yeah.
Okay. Now, just quickly, I want to talk about a couple bills that died that we are likely to see efforts made next year. Senate Bill 1785 was a firearms bill. And there was an effort being made to say that a legally owned firearm, that association would be prohibited from restricting an owner from bringing a firearm onto the common area, into the clubhouse. You would not be allowed to prohibit someone from bringing a gun into the clubhouse if this bill had been signed. We had a lot of concern about that. I mean, there was the incident, it was 10 years ago, where there was a board member that was shot. So there were some concerns. This bill died, thankfully. I don't think it was a good bill, but I mean, it had some problems the way it was written, and so I'm sure there lots of opinions on this issue. But that was a bill that was out there that died. There were multiple bills dealing with CC&R amendments. This will come up again next year. There's going to be an effort made to try to simplify and make it a little easier to amend CC&Rs. But there were already attempts this session that didn't succeed to try to do that. There were 6 or 7 bills on short-term rentals. These are not, none of these had a direct impact on associations. They were all at the city or county level. But there were two clear camps that were established. One to say get rid of any restrictions or the ability to restrict short term, and the other was let's continue to restrict, and how do we do it? None of these were successful, but it is on the minds of many legislators, and I think it will come up again. And then there was an effort at the beginning of this session by a group of owners to change the open meeting laws, and that kind of died on the vine. But I think that there might be an effort again next session to maybe revisit that. And some of the changes were going to be to address what we've all been dealing with over the last year with COVID, and how do you handle annual meetings on Zoom? What are the rules for Zoom meetings, things like that. And there was going to be some language to address that, but that didn't go over anywhere. So could expect that next year as well. Might see that change. So those are the bills that. In fact, let me do something here. Okay, so those are the bills that I was looking at that were signed, and some of those bills that may still come into fruition. You know, I'm sure you'll receive blasts from the industry if they are signed, those 2030 and 2052, and that bill about condominiums, or if they don't, I'm sure you'll hear about it. But they're still in limbo right now as we sit here today. So the last thing I want to do in the last 10 minutes or so that we have, 5 minutes, is give you just a brief overview of some cases that have been decided in the last, I think some of these go back 2 years. And I put my, got too many papers on my desk. Hold on 1 second. I got to find my notes. The reason I want to bring these up is, I mean, some of these are pretty boring to read, but they address some topics that I think are important for us. And it does give a little bit of guidance on these topics for maybe future questions and concerns that come up. This first case, Arizona Biltmore Hotel Villas, and I will tell you, I was not the attorney on any of these cases, so I don't know all the intricate details about what happened. I'm just giving you a very brief 20,000 foot view of what was decided and how this might impact us down the road. But this Arizona Biltmore Hotel Villas condo versus Conlon Group is a case that was going on for a long time. I mean, I think it goes back to 2008, 9, 10. Various lawsuits were filed, but the thing to take away from this case is that a board president and this Conlon Group, which I think was the board president's company that owned a bunch of units. You know, you get this question that comes up every once in a while about conflicts of interest and the requirement to disclose conflicts. And there is the statute in the Planned Communities Act, Condominium Act, but there's also a group of statutes in the Nonprofit Act regarding disclosures. And this case goes into a pretty in-depth discussion about what this board president should have disclosed that he didn't, and why he was held financially responsible for damages suffered by the association as a result. And it had to do with some self-dealing claims, different groups involved in various lawsuits over parking spaces, things like that. But there's an interesting analysis that this board president did not disclose what he should have disclosed as part of this deal and was held financially responsible for some damages. So it's an interesting case that talks about disclosure requirements. The Sunburst Farms versus Braden case was a lawsuit involving CC&R amendments. There's various stages of this Sunburst Farms. We don't represent them. I'm not as familiar with that association. If someone is, you can let me know. But there were attempts to amend the CC&Rs with these various stages. And there's an analysis in this case that's kind of interesting on what it takes to amend CC&Rs, whether you have to have unanimous approval. Sometimes you hear attorneys will talk about how you have to get the vote of 100% of the owners for certain things. It goes into an analysis on that. It also talks about the legitimacy of a ballot. You know, in the absentee ballot statutes, it talks about how you have to give an owner an opportunity to vote for or against every measure. These questions come up on election ballots. Do we have to put a yes and a no space, to vote yes or no for a candidate? There's a discussion about the legitimacy of their ballot to amend their CC&Rs, and the way that, and it shows an example of what they wrote, and the court found that their ballot was okay, and it found that their majority approval requirement was okay. But the problem the association had was when they did an analysis of the votes that were counted, they actually didn't get enough votes to make the amendment valid, and they invalidated the amendment. So it's an interesting decision or discussion about the amendment process, ballots, things like that. Levine Meadows HOA versus Mejia was a case that was recently decided that has to do with assessment collections and foreclosure. There are some attorneys out there who represent homeowners that would take the tactic of having their client pay the assessments as a way of stopping the foreclosure because of that statutory requirement where someone is delinquent in the payment of assessments by a year or $1,200. So if someone goes and pays all the assessments, the argument is that the court no longer can hear the case. And a lot of judges were agreeing with his argument. And so this case goes into an analysis of what it means to pay off the lien. Some of this has since been resolved by statute. There were the revisions to the statutes in 2019 to 33-1807 and 33-1256 revised this and clarified this as to what, once a lawsuit is filed, if someone wants to resolve it, they have to pay off the entire lien, not just the assessments. That's how it's going to operate going forward. But this case talks a lot about that. If anyone's interested in reading that, Montana Ranch case. The reason I put this one on the list is this is a case that goes into an analysis about group homes and whether or not group homes receive the protection from the Fair Housing Act for the reasonable accommodation requests. Goes into an analysis about disabilities and whether group homes, and they find in favor of the group homes that it is if someone makes a reasonable accommodation request for a group home, you're going to have to allow it if it meets the other requirements from the fair housing analysis. But group homes are part of this category. I think most attorneys have already kind of made that assumption and given that opinion that they are. I know I have, but this case goes into some discussion about that. The McGrath versus Judson Community Association. Whoops. This is a case that has to that deals with the McGraths installed artificial turf in their front yard and didn't have approval. Association came to them and said, hey, wait a sec, you made a change to your property, you didn't seek architectural approval, you need to submit for it so we can review it. And in the meantime, they'd issued a fine. And so they submitted for approval, but interestingly enough, these owners proactively went out and sued the association to say that you don't have to require us to do this, you can't tell us no, you can't charge us a fine. It wasn't the other way around where the association sues because someone made changes without approval. And so the court goes through an analysis about the CC&Rs, how these owners are obligated to abide by the CC&Rs, and it rules in favor of the association that these people did not have the approval. They were required to have the approval and they didn't get it. So it's a win for an association. Sometimes these enforcement cases can be a little tough, and a lot of judges don't like enforcement cases, and will find ways to either split the baby or rule against an association. So this was a favorable ruling for this particular association. Tarter versus Bent. I put this one on here because it's a fascinating case that has to deal with defamation. Tarter is an attorney in town. He was the board president of this association, or maybe the vice. I think he was the president. The Bent name on here was an owner in the community, and after Tarter was elected to the board, Bent, husband and wife, took it upon themselves to just lash out at this particular individual, and released. And again, I don't know all the details, but from the summary I read, is there was a newsletter posted. There were all these comments made about his ethical violations, his dishonesty. I mean, all this stuff, and it was bad. and it lasted for quite a while, until the point where Tarter filed a defamation lawsuit against the Bents. And one of the reasons I wanted to bring this one up is because this case went to a jury, and the jury awarded Mr. Tarter, let's see, I had to write it down here because it was so crazy, awarded him $500,000 in compensatory damages. Now, these included damages to his reputation and emotional harm, awarded him $1 million in punitive damages against these owners, and then I think $21,000 in costs. And they appealed this decision, and the court upheld the decision and the award of damages. And if you Google this, you can actually watch the oral argument. I mean, if you're really bored one day, and if you want to watch the oral argument on this case, it's pretty interesting. But it's just, I think this is tossed around a lot, well, they're defaming me, this and that. And I don't think most people ever take these types of cases. I think this one was a little different because the plaintiff was an attorney, and they were attacking his livelihood. But they came back with a huge award of damages, and that was upheld. So an interesting result there. The last case on here, this Nick Don 10663 versus Desert Mountain. This was a recent case that came down that had to deal with an amendment to the CC&Rs involving short-term rentals. And there's a in-depth analysis as to whether or not the association followed the process correctly and had the authority to change the CC&Rs to insert short-term language, short-term rental language. And the argument that some of the attorneys I know that were concerned about is whether or not, if you make a change to your CC&Rs and insert this type of language, whether there's an argument out there that you have to get approval from all the owners. And they talk about this. They talk about this old case, this Dreamland Villas case that you may have heard about, and talks about how it applies, how it doesn't apply. And at the end of the day, the association prevailed on this, and their amendment was upheld, that they were allowed to insert this short-term rental using the percentage requirement to approve the CC&R amendment that's in the documents. I think it was 2/3 or 75%. They didn't have to get the 100% approval. So this isn't going to be applied across the board. I think there still are ways in which an association, if they want to change their documents, may trigger that 100% requirement. But it is an interesting analysis of that process. So you can Google any one of these names and find the case law online if you want to read it. So, and with that, I think we're right at the hour. If there are any questions at the end here, if you have any questions, if you think of something in 5 minutes and want to send me an email, please do. I'm happy to answer your questions. But for those of you who need credit, reach out to Terry, and she can provide you with whatever you need for that. And thank you for your time today.
Thank you.
Thank you. Have a good day.
Hi. How are you?